I think, Mansi, we shall start now.
The edifice of the stable democratic society and the constitutional rights and duties are based on the coexistence of communities. Any attempt to vilify a community must be viewed with disfavor. Greetings of the day, everyone. On behalf of the Delhi Judicial Reforms Council, I extend a warm welcome to the esteemed speaker and the participants who have taken this platform as an opportunity to media trials shaping public perception and its impact on the judiciary. Delhi Judicial Reforms Council, having been formed under National Judicial Reforms Council under the aegis of WICI, that is Women's India Chamber of Commerce and Industry, is a women run initiative. The council has been working for the betterment and upliftment of the society by addressing the core issues that surround society. Media trials play a significant role in shaping public perception by influencing how people perceive a particular case or individual involved. The impact on the judiciary is that media trials can create pressure, bias, and even prejudice, which may affect the impartiality of the judicial process. It's, it's an important topic to reflect upon and discuss. The discussion will focus to discover the nexus between media narratives and legal system. Our guest speaker for today, Professor Dr. Shailendra Kumar Gupta, is a trailblazing professor of law at Banaras Hindu University. To begin, I would like to invite Ms. Shreya Singh, Vice President of Delhi Judicial Reforms Council, to give the welcome address. The Vice President of Delhi Judicial Reforms Council, Shreya Singh, is also a respected advocate. She has been with the council for many years and has gained a lot of experience. Her journey from being a council member in NJRC to the vice president of DJRC has been an exciting and rewarding experience. Over to you, Shreya.
Thank you, Mansi. A very good evening to everyone. I hope you all are doing well. We are honored to have Sir as our guest speaker for today's event. In today's digital era, media plays an important role in influencing how we perceive world around us. It has the power to shape public opinion, including our understanding of judiciary system. To enhance our knowledge on the same, Dr. Shailendra Kumar Gupta sir will delve into the complexities of how media can impact the public opinions, their perceptions, and the judiciary system. Thank you.
In order to make this event more interactive, we have three participants who wish to express their views on today's topic of discussion. Let us hear their views one after the other. Firstly, I would like to invite Ms. Akshita Nath to present her views. Akshita, are you there? There might be some network issues. Now, I would like to invite Mohammad Aman Yusuf to, to be here. Vishaka, your voice was breaking. So, moving forward, it's now the time to invite our special guest of the evening, Professor Dr. Shailendra Gupta. Dr. Shailendra Gupta. Dr. Shailendra Gupta's expertise extends beyond academia, spearheading the multidisciplinary academic at BHU, hosting over 350 enlightening sessions. Professor Gupta has special interest in public education and advocacy. He is also the member of Consumer Advocacy Group as well as the founding trustee of the Just Discourses Foundation Trust, New Delhi. Professor Gupta, as BHU Legal Aid Clinic's Executive Director, filed a PIL in Allahabad High Court on inhuman conditions in UP prisons. Ongoing, it led to the court directives. He pioneered various initiatives, including legal aid centers, workshops, and summer trainings. With the Varanasi District Probation Office, he established a center at Juvenile Home. Professor Gupta mentored 50 plus student volunteers, emphasizing leadership and social service. His research project with Professor David W. Thomas on the Legal Aid Clinic in India was published in an international law journal. Professor Gupta sincerely believes in the cherished vision of the great Indian civilization, which aims to achieve the goal of one earth, one family. We welcome you, sir. I request Dr. Shailendra Kumar Gupta, sir, to bestow his wisdom and share his valuable insights. Over to you, sir.
So, very good evening to all the distinguished participants. Honorable Office Bearer of National Judicial Reform Commission and its important chapter, that is the Delhi Judicial Reform Committee. First of all, I would like to express my gratitude to the office bearers of DGRC for inviting me to share my views with the participants of this distinguished organization. Perhaps this organization consists of very young students and advocates, if I'm not wrong. It has been a matter of great pleasure for me to spend time with the young generation and to interact with them, because the young generations are future of our nation. And I'm very happy that the many of you who are so young, you are the part of Delhi Judicial Reform Committee. Being a young members, you are thinking about reforms, legal reforms. It means the future of my country is in the safe hand. I have been given a topic which talks about media trials, shaping public perception, and impact on judiciary. Friend, being a student of constitutional law and public law, including jurisprudence, I think that first of all, I should acknowledge the power of media The press or media has been considered as the fourth pillar of democracy. After legislation, legislature, executive, and judiciary, the media or press has been considered as the fourth important pillar of democracy. The democracy does not mean that we should go and exercise our power right to vote once in a 5 years. Democracy means continuous interaction, exchange of views, try to be accommodative, try to respect the views of our opposite side, and try to develop the value of tolerance. Because in democracy, everybody is free to express their views, perception, ideologies. You may agree, you may not agree. This is not necessary that the other members of the society must conform to your views. This is not necessary. So if we want to see that our democracy should survive and thrive, and it should be strengthened, we must take this pillar, press and media, very seriously. Friend, being a student of constitutional law, I'm aware about the 6 freedoms which have been recognized by our founding fathers under Article 19. And the first freedom talks about the fundamental right to speech and expression, freedom of speech and expression. Friend, as you are all aware about that the freedom of press has not been specifically recognized under the Constitution of India. Of course, there are certain modern progressive democracies and constitution where the freedom of press has been specifically recognized under the constitution and laws. But in India, the freedom of press has not been specifically recognized as a fundamental freedom. The credit should be given to our Honorable Supreme Court that at the initial stage of our democracy has specifically recognized that right to press is the part of Article 19(1)(a). Right to press is the integral part of the freedom of speech and expression. The citizens exercise their freedom of speech and expression through the press. And that's why the freedom of press is also the part of the fundamental right of freedom of speech and expression. Friend, hundreds of the books have been written, thousands of the articles have been written on right to freedom of speech and expression and right to press. Hundreds of the landmark decisions have been delivered by the Honorable Supreme Court and High Courts. Many research PhD works and LLM dissertations have been done on this topic. Many landmark cases have been decided by the Supreme Court, wherein the Supreme Court has dealt one or another aspects of the right to press. It may be the volume of the press, it may be the content of the press, it may be the size of the press, it may be the number of pages, it may be the territorial circulation of the press. Of course, the government has power to restrict the freedom of press in certain national emergency situations. And of course, during the infamous emergency, the then central government has imposed a severe restriction on the freedom of press in India. We are all aware about that. But friend, one thing more of which I would like to point out, that conceptually, no fundamental right is absolute, except one or two exceptions. Most of the fundamental rights, they are not absolute. They are subject to certain reasonable restrictions. Friend, of course, you all are aware that if you see the history of the constitution of the world, you are all aware that it was the American Constitution which first time formally recognized the existence of fundamental right in their constitution through their first amendments. In the American original constitution, the fundamental rights were not written, because those who made the constitution, they said that there is no need of writing the fundamental right, because they believe that no government will control or regulate the fundamental right. It is presumed that every government will honor the fundamental right. And that's why when they wrote the constitution, they didn't think that there is a need of writing specifically fundamental rights under the Constitution of America. But subsequently, the American constitutional functionaries realized that no, there is a need of recognition of fundamental right under the supreme law of the land, that is the American Constitution. But when the fundamental rights were written in the American Constitution, again, one problem was there. The fundamental rights were written without any restriction, without any if and but. It means, in other words, the fundamental rights were written in the absolute form. And naturally, subsequently, the problem arose under the American Constitution. Okay, you may have the fundamental right to liberty, but the liberty cannot be absolute. In the name of the liberty, you cannot harm the society. You cannot harm the interest of the society. The man is for the society, not above the society. The larger public good, the larger public interest is supreme. And that's why when an individual fundamental liberty contradicts with larger public good, naturally the larger public good must prevail over the individual liberty. Friends, some of you may not agree with me, but because of the paucity of time, perhaps I cannot explain in detail what I really mean to say. I'm not denying the importance of individual liberty and individual freedom and autonomy of individual. I'm not denying. But I'm just trying to draw your kind attention on this point that there should be or there may be some limitation on individual liberty. And particularly when the individual liberty comes into conflict with larger public interest or larger public good. And therefore, friend, most of you are legal professionals, I suppose. Honorable Supreme Court of America has developed a constitutional jurisprudence wherein the doctrine of police power has been established. Means right of state to regulate the liberty. That is the police power of the state. And therefore, friend, when our founding fathers, they were debating on this issue that whether freedom and liberty should be given without any restriction or not, they were well aware about this development of American constitutional law. And therefore, our founding fathers, they have written the 6 freedoms under Article 19, but on the same time, they have written reasonable restrictions specifically. Every freedom is subject to certain reasonable restrictions. And fundamental right to speech and expression is not exception to that. Friend, before talking about media trial and its impact on public perception and on judges and judiciary, let us try to understand some jurisprudential perspective of this issue. Friend, I'm a student of jurisprudence also. That is my area of interest. Jurisprudence is considered as the mother of law. If someone is not aware about the jurisprudential principles, theories, concepts, it is very difficult for him or her to understand the concept of law or provision. I used to say that for a student of law, or for any scholar of law, the three things are important. The first, that is the jurisprudence, what law ought to be, what is the concept of law, what is the relationship between law and morality, what is the very objective of law, what is the relationship between law and justice, what is the relationship between law and values, what is human right. Issues of jurisprudence. I'm sorry, there is some disturbance of calls. Okay, anyway. So, friend, as a faculty member, I would like to advise the young professional and students that if you want to do some serious thing in your life, if you are really serious in legal profession, the first condition is to develop your capacity, your understanding about jurisprudence. Because for any student, for any professional, for any judge, for any advocate, what law is may be important, but what law ought to be is more important. And this is extremely difficult. This is extremely difficult to decide what law ought to be. Friend, are you not aware that recently the Supreme Court has delivered a judgment on same-sex marriage? And you may be surprised to know that we are having a very reputed, learned Chief Justice of India. But what happened in that case? Honorable Mr. Chief Justice of India has become minority. The judgment was delivered from 3 to 2. He wanted to provide legality to same-sex marriage, but he reduced into minority. So, friend, what I want to say is that when Indian Supreme Court has been considered as one of the strongest court of the world, this is the opinion of a jurist, Professor Upendra Bakshi, who is well known to every student of law. Professor S.P. Sathe has written a book, Judicial Activism in India, and Professor Upendra Bakshi has written the foreword of that book, and both have the same view that Indian Supreme Court is the strongest court of the world. But look, friend, the Chief Justice of India, who is considered as one of a very learned judge having illustrious judicial career, whose integrity is beyond doubt. But he himself finds into minority. The three majority judges, they didn't agree with the views of minority judges, including Chief Justice of India. And that's why, friend, what law ought to be? This is extremely difficult question. And friend, I was talking about jurisprudence is most important thing. After jurisprudence, the second most important thing for a legal professional, that is the Constitution. Since this forum is Judicial Reform Commission or Committee, I'm sorry, Delhi Judicial Reform Committee. Friend, if you want to reform the law, you need three things. You need three things. Am I audible?
Yes, sir, you're audible.
You're audible, sir.
So sorry that someone is constantly ringing me. Okay, anyway. So friend, I was talking about that your organization belongs to Judicial Reform Committee. Friend, I'm elder in age and experience. And I would advise all my young friends that if you are really serious about judicial reform, please, for the God's sake, take the three things very seriously. The first thing is jurisprudence, what law ought to be. The second is supreme law of the land, that is the constitution or constitutional law. And the third is interpretation of statute, which is also known as applied jurisprudence. If you will be able to develop the expertise in these three areas, it will be easier for you for undertaking any kind of reform, including judicial reform. So, friend, let me devote some time on the jurisprudential perspective of this topic. I would like to present the two schools which is relevant here. The first is legal realism, or popularly known as realist school. Friend, in your LLB course, your teachers must have taught you that legal realism or realist school, it is a reaction against analytical positivism or Austinian approach. Analytical positivism says that law is command of sovereign, The paper rules are the real rules. The legislations are real laws. But realist school does not agree with this view. Realist school says that the legislations or rules, they are paper rules. They exist on paper. And friend, perhaps most of you are lawyers, and particularly those who interacted with me and invited with me, I found that you are all lawyers, young lawyers. And friend, being a young lawyer, sometimes or most of the time, you may be amazed to see that whatever was taught to you in the law school, that does not exist in the court. The practice in the court and procedure in the court, environment in the court is quite different. What exists in the CRPC, CPC or evidence, the things are different in practice. What has been taught to you in the name of professional ethics does not exist on ground realities. The theory and practice, east and west. So friend, realist school says that law is not command of sovereign or law is not command of parliament. Rather, law is judicial decision. What judges do in a particular case, that is the law. And friend, perhaps we should agree with this viewpoint to some extent. The parliament makes so many laws, but we get the laws through the courts, through the executive. Whenever there is a dispute, we go to the court. And what judges interpret and what judges give us in the form of judicial decision or judicial directions, that is the real law. No, CRPC does not say that if a sexual assault has been done with anybody, we teach our students in the classroom that, look, this is the provision of the IPC, this is the provision of the CRPC, and this person will get 15 years imprisonment or he will be hanged, or 10 years imprisonment. But friend, you are all lawyers. If one crime of sexual assault took place today, perhaps you will agree that from Indian standard, the case may be decided after 10 years, after 15 years. No, the teachers do not teach the students in the classroom this. You need a lot of money to fight the cases. You have to pay to the lawyers, and 98% of the lawyers will not act unless you pay them. How many lawyers are there who may be ready to work pro bono? So there is a decline in every profession. So is the case of legal profession and advocacy also. बिना पैसा लिए लॉयर आपसे बात भी नहीं करेगा, क्योंकि वो कहता है कि मेरे टाइम वहां टाइम की कीमत है भाई। मैं 2% लोगों की बात नहीं कर रहा हूं, या 5% पब्लिक स्पिरिटेड लॉयर्स की बात नहीं कर रहा हूं, मैं 95% लॉयर्स की बात कर रहा हूं। तो भाई जो प्रोफेशनल एथिक्स में हमें पढ़ाया गया था लॉ स्कूल में, वो कचहरी में दिखाई नहीं देता है जनरली। Okay, I will not allow myself to deviate much more. लेकिन थोड़ा टीचर्स की एक बड़ी खराब आदत होती है, कोई भी टॉपिक दो तो वो बोलते वही हैं जो उनको आता है। पढ़ते पढ़ते हमारा भी एक माइंडसेट बन जाता है और हम घूम फिर करके वहीं पहुंच जाते हैं। तो प्लीज एक्सक्यूज मी इफ आई एम डिविएटिंग हियर एंड देयर। So friend, what I'm talking about is that, look friend, realist school says that law is not command of sovereign. Law is not the historical analysis, but law is judicial decision. And friend, look, realist school also says that judicial decision is reflection of the whole life of a judge. When a judge writes his decision, in fact, the whole value system of that judge, whole philosophy of that judge, whole personality of the judge, whole thinking of the judge, ideology of the judge gets reflected in their judicial decisions. You are all aware about that. Friend, being a lawyer, you are well aware that certain judges are very liberal, certain judges are very conservative, certain judges are corrupt, certain judges are honest, certain judges are very liberal to allow the bail, but certain judges are very strict. Certain judges are feminist, certain judges are patriarchal approach. Certain judges are capitalist, certain judges are communist minded, certain judges are socialist, certain judges are pro farmer, certain judges are against farmer, certain judges are pro labor, certain judges are against labor. We are all aware about that. So certain judges are in favor of the legality of the same-sex marriage, but certain judges are not ready. Friend, being a student of law, every day we visit on the legal portal Live Law. Octopus, this portal, that portal, Indian Kanun, Manupatra, every day. Hundreds of the judicial decisions are being given by the Supreme Court and High Courts and District Courts. And since you are a lawyer, when you prepare a case, you prepare for precedent. How many cases have been in your favor and how many cases are against you? You do a lot of research work. The senior lawyers, they have a very large team of junior lawyers. And what junior lawyers do? They do research, case laws. How many cases have been decided in your favor and against favor? You do a lot of research work. And those who are able to do this research work genuinely, smartly, they win the case. This is the lawyering. Generally, a district court cannot go beyond what Honorable High Court has decided. District court cannot go beyond what Honorable Supreme Court has decided. So when we go in the district court, our whole energy goes for how many high courts and Supreme Court cases are in my favor, in clients of my favor. Look, friend, sometimes you find that many cases have been decided in one way or another way, in your favor, in against you also. And sometimes you get confused. And you think that why judges are deciding in such a contradictory manner? Why all judges are not deciding in the same way? Why so much chaos is there? Judicial decisions create a kind of chaos. One judge is saying this, and another judge is saying that, another judge is saying that. और उन सारे केसेस को पढ़ते पढ़ते दिमाग का जो है वो दही बन जाता है. Friend, it is because every judge is different. Why cases are decided differently? Very obvious, very clear, very simple. Because judges are different. Their ideologies are different. Their education is different. Their perception is different. Their value system is different. Their social background is different. Their caste is different. Their religion is different. Their gender is different. Now you will be thinking that why sir is talking about all these things. But friend, what I'm talking about, friend, what we do, look, what we do when we get up in the morning. When we get up in the morning, after one or two essential things, we pick up the newspaper. Or nowadays, we are reading all the news in our mobile. And when we read a newspaper, what happens? Let us try to understand the psychological process. Take psychology seriously. When we read a newspaper, in our subconscious mind, We take information, we take knowledge, we take perception. What has been published in the newspaper? What is the headline? Look, friend, most of us start from the front page. Nowadays, newspaper consists of sometimes 20 pages, 30 pages, 40 pages. Do we have time to read the 40 pages? No. 90% people just read first 2 or 3 pages only. Or some serious students or serious scholars, they go for the editorial page. But 80% people, they just first page, second page, third page, not on the even fourth page. So what is published on the front page and what is the first news and what is the font size of that news, that matters. Are you reading Times of India or Hindu or Panchajanya or Indian Express? %99 of the people, they read only one newspaper. Am I correct? We read only one newspaper because we don't think that we need more than one newspaper. Friend, in my career, I have read many newspaper or I have heard about many newspaper. Some of my friends are journalists. I have some information about the newspaper, which newspaper have which kind of, because most of the newspaper, they belongs to the industrialist group. The common man is not the owner of the newspaper. Tell me only one newspaper which is owned by some common man or some group of common man or a society. 99% of the newspaper either belongs to this industrialist group or that industrialist group. This businessman or that businessman, this capitalist group or that capitalist group, this political party or that political party. अगर हिंदू न्यूज़पेपर में मोदी जी के फेवर में अगर कोई न्यूज छप जाए तो मैं कहूंगा कि ये आज की ये न्यूज होगी आज की, क्योंकि हिंदू विल नॉट पब्लिश ए सिंगल न्यूज praising even slightly to Prime Minister Modi. जब तक रवीश कुमार एनडीटीवी में थे, करीब मैंने 10 साल तक एनडीटीवी सुनी. मेरे फेवरेट हैं वो. अच्छे स्कॉलर हैं, सिंसियर आदमी हैं, पब्लिक स्पिरिटेड पर्सन हैं. लेकिन कुछ दिनों के बाद मुझे ये रियलाइज हुआ, अरे भाई ये बंदा तो कभी एक शब्द भी सेंट्रल गवर्नमेंट के फेवर में बोलता ही नहीं है. तो पिछले 8 सालों में क्या मोदी गवर्नमेंट ने एक भी अच्छा काम नहीं किया? एक, नॉट अ सिंगल थिंग. अरे कभी तो अपने मुंह से निकाल दो भाई कि ये भी एक अच्छा काम हुआ है. to a particular ideology. You are not neutral. और जो बात रवीश कुमार के ऊपर लागू होती है वही बात जो है वो आज तक के चौधरी जी पर भी लागू होती है, जो पहले जी न्यूज में थे। सुधीर चौधरी, वेरी पॉपुलर, वो कांग्रेस के बारे में एक शब्द नहीं बोल सकते अच्छाई। कभी आज तक मैंने उनको नहीं सुना कि कांग्रेस ने कोई अच्छा भी काम किया है। सो व्हाट इज दिस? इज इट मीडिया? और इसीलिए लोगों ने देखा कि भैया ये एनडीटीवी तो रवीश कुमार रोज 1 घंटे मोदी जी के खिलाफ बोलता है पिछले 10 सालों से, तो उन्होंने अडानी जी से कहलवा करके एनडीटीवी ही खरीद लिया। आपको मालूम है ना, एनडीटीवी जो इतना पॉपुलर और प्रोग्रेसिव न्यूज चैनल है इंडिया का, आज वो अडानी उसका ओनर है, खरीद लिया अडानी जी ने। और जैसे ही खरीदा और उसके सारे जितने भी सो कॉल्ड प्रोग्रेसिव लिबरल्स वो थे सबको जाना पड़ा, इंक्लूडिंग रवीश कुमार। अब उनकी रोजी रोटी जो है वो यूट्यूब के भरोसे चल रही है। So friend, what I'm talking about, देखिए, look friend, most of the judicial decisions are nothing but reflection of personality of a judge. You tell, जैसे आप कहते हैं ना, आप लॉयरिंग, देखिए लॉयरिंग स्किल क्या आपको सिखाई जाती है, लॉयरिंग स्किल, आपको बेल कैसे लेनी है, आपको सिखाया जाता है। सुनो भाई, इस समय जो जज साहब है ना बड़े टफ हैं, बड़े ईमानदार हैं, तुम्हारे केस में वो बेल देंगे नहीं। तो आप अपने क्लाइंट को समझाते हैं भैया थोड़ी देर अभी और जेल में रहो, अभी 6 महीने बाद ये जज साहब जब बदल जाएंगे, दूसरे जज आएंगे, फेवरेबल जज, तब आपकी हम बेल एप्लीकेशन लगा देंगे। देखिए आप कितने बुद्धिमान हैं, हाउ स्मार्ट यू आर। You know, being a lawyer, you know this. You know the personality of the judge. You know the ideology of the judge. You know the what is the approach of a particular judge. किसकी कोर्ट में मुझे जाना चाहिए, आपको पता है। हाई कोर्ट से रिजेक्ट होती है तो सुप्रीम कोर्ट का जज आपका एक्सेप्ट कर लेता है। इसका मतलब नीचे वाले क्या बेवकूफ थे जिन्होंने रिजेक्ट किया था आपकी बेल को। फैक्ट सेम है, लॉ सेम है, सीआरपीसी सेम है, बेल के रूल सेम है, law is same but judicial decisions are different. And that's why reality school says that law is not what is written in the IPC or CRPC or evidence, but law is that which has been given by a judge through his judicial decision. आईपीसी में लिखा होगा कि सेक्सुअल असॉल्ट के लिए 15 साल की जेल हो सकती है, लेकिन जज साहब ने आपको क्या दिया, जज साहब ने केवल 2 साल की सजा दे दी, 15 साल नहीं दी। कोई दूसरा जज उसी केस में वो 10 साल की सजा दे देता है। फैक्ट्स आर सेम, लेकिन कोई 10 साल की सजा दे रहा है, कोई 2 साल की सजा दे रहा है। लॉ इज सेम, प्रोविजन इज सेम, But since judge is different, that's why, and since their ideology is different, and that's why their penology, principles of penology is different. So really, school, and look, friend, this is the era of judicial activism. I have also taught environmental law for a few years, and I'm aware that certain judges, they read the newspaper. Let me specifically point out the famous Kamal Nath case. He was the Union Environment Minister at that time when his family constructed a motel in Himachal Pradesh at the bank of river Vyas. He misused his power. Against all the environmental norms, he constructed a motel, obstructed the very natural flow of the river Vyas. A news item has been published in the newspaper, Indian Express. And somebody has, and then Justice Kuldeep Singh, a green judge, when somebody has brought into his knowledge, so, my lord, this newspaper has been published, this news item, look, do you know what he has done? He has converted the news item in the form of a writ petition. He took the suo motu action. And rest is the history. Kamal Nath case is the landmark judgment given by Honorable Supreme Court of India that has created an environmental jurisprudence. This is the power of the media, impact of the media on judges. There are many cases where a rape has been happened and a newspaper or a news channel has telecasted that, and Supreme Court took the suo motu decision, suo motu action in many cases. So friend, what I want to say is that, but I'll come on this point, but let me finish that point. Release school. So release school says that law is a matter of prediction. Justice Holmes has said that, a very famous jurist of realist school, that the prophecies of what law and nothing more pretentious is what I mean by the law. Prophecies means prediction. What a particular judge will decide to predict that is the law. And rest of the thing is false narrative. Friend, as you may be knowing, certain judges are, friend, so many of my students are judges in the district court. And they often come and they interact with me. And what they say on bail cases, sir, we do not give the bail generally. Even if law permits, we do not give the bail. I ask, why? Why you are not giving the bail? Sir, if I will give the bail, there may be a doubt that I have taken the money. So, if I have decided and I have given the bail in the case, I may be in trouble. I may face an inquiry, allegation that I have taken money and I'm very liberal to give the bail. And that's why, sir, we take a precautionary approach and generally we reject the bail application. Even if we genuinely feel that bail should be given, but we generally, as a matter of policy, in order to protect our long-term interest, we deny the bail. Why? Because let my senior give the bail. Let the High Court should give the bail. And there, in fact, there may be the judges who may take the money and give the bail. सबसे ज्यादा पैसा तो इसी में है, क्योंकि जजेस को डिस्क्रिप्शन है बेल देने का. सबसे इजियर तरीका है पैसा लेने का. खैर, मैं और ज्यादा उसमें बेल जूरिस्प्रूडेंस पे मैं नहीं जाना चाहूंगा, लेकिन जस्ट व्हाट आई वांट टू से इज दैट often what is going on in your mind, it gets reflected in the form of the judgments. And friend, one thing more. There is a very interesting jurisprudential school which is known as postmodernism and critical legal studies. The postmodernism says that the law is socially and culturally constructed phenomena. The law represents the power, political power. Law is a kind of meta-narratives. The law is made by the parliament. Parliament consists of members of the parliament. And what they think they make law. So the law may be against labor, the law may be against poor, the law may be against farmers, the law may be against small scale industry, the law may be against small traders. Law is socially and culturally constructed phenomena. Law represents the power. Whosoever is having the power, they shape the law. Friend, you have given me this topic, media trial shaping public perception and impact on judiciary. Public perception. I would request you to give some attention on why all the political parties are very much interested to have influence or control over media. Why all political parties, they have a very good relationship with the media houses and the persons who own media. Why all the political parties, they want to have their own newspaper. You go in the Tamil Nadu, you will find that most of the news channels, they are either owned by DMK or AIDMK. What Modi ji speaks, it does not go into the ordinary Tamilians, because all the Dravidian parties, either DMK or AIDMK, they have the full control over media, television channels. All the channels belongs to them. So media plays a very important role in shaping the perception. They influence the elections. Often we cast our vote on the basis of what is published in the newspaper. In India, what is the literacy rate even today? And even how many persons are really literate? Literacy does not mean that I'm a graduate. But how many citizens are well informed, well educated? How many Indians are in a position to take a wise decision or option? Friend, I do not know whether you are aware about this or not, but in India, 95 to 96% of we, the people of India, we cast our vote on the basis of either religion or caste or gender or this or that. We do not see a candidate as an individual. We vote for our religion, for our caste, for our people, for our district. And that's why in India, we may have the largest democracy, but we do not have the qualitative democracy. We are far behind, miles to go. And friend, critical legal studies and postmodernism, they are perhaps to some extent right when they say that law is power. It is the powerful groups in the society that decide the law. Sometimes, often the majority decide the law, which is known as the majoritarianism. ये एक दूसरा विषय है कि हिंदुस्तान में बहुत सारे लॉज जो है वो माइनॉरिटी अपीजमेंट के लिए भी बनाए गए हैं. हिंदुस्तान पूरी दुनिया में एक अनोखा देश है कुछ मामलों में, जहां लॉज माइनॉरिटी अपीजमेंट के लिए भी बनाए गए हैं. फ्रेंड, आप पब्लिक परसेप्शन की बात कर रहे हैं. आज हमास और इजराइल के बीच में पिछले 1 महीने से वॉर चल रहा है. हम उसके बारे में ओपिनियन जब बनाते हैं तो हम किस आधार पर बनाते हैं? ऑन व्हाट बेसिस वी फॉर्म आवर ओपिनियन? मैं दावे के साथ कह सकता हूं कि आप एक पर्टिकुलर चैनल देखिए, अल जजीरा देखिए, आपको इजराइल से घृणा हो जाएगी. आप प्रो पैलेस्टाइन हो जाएंगे, प्रो हमास हो जाएंगे. बस केवल आप अल जजीरा देखिए, जिसका मालिक कतार है. हमास के 1200 लोगों ने पैराग्लाइडर, चीन का बना हुआ पैराग्लाइडर लेकर के रात में ऊपर से उड़ते हुए गए और 1200-1300 सिविलियंस, इनोसेंट सिविलियंस को मार दिया, रेप किया, सेक्सुअल असॉल्ट किया. ये अल जजीरा को दिखाई नहीं देता है। और इजराइल, जिसके बारे में पूरी दुनिया को पता है कि वो कैसे रेस्पॉन्ड करता है, अगर उसके सिटीजन्स पर अटैक होता है तो वो कैसे रिस्पॉन्ड करता है, ये पूरी दुनिया को मालूम है, हर आदमी को मालूम है। 5-5, 6-6 अरब के देश 3 बार इजराइल पर अटैक कर चुके हैं और हर बार वो हार चुके हैं। इजराइल आज जो है वर्ल्ड में टेक्नोलॉजी का वो जो है एक तरीके से वो कुछ मामलों में वो सुपर पावर है, अमेरिका से भी आगे है इजराइल, मेडिकल टेक्नोलॉजी में, ड्रोन में, आर्म्स टेक्नोलॉजी में। अगर इजराइल चाहे तो 5 मिनट के अंदर जितने भी 10-12 अरब कंट्रीज हैं सब रेगिस्तान बन जाएंगे, इतना न्यूक्लियर आर्सेनल उसके पास है, इजराइल के पास। तो जब आपको मालूम है कि इजराइल इस तरीके की कंट्री है, तो आप 12 और 25,000 जो है वो पैलेस्टाइन पर डे इजराइल में जाते हैं, अपना आई कार्ड दिखा करके दिन भर काम करते हैं, शाम को अपना जो वेजेस लेकर के वापस आते हैं। अच्छा खासा दुनिया चल रही थी, शांति से चल रही थी, पैलेस्टीनियन आराम से पढ़ लिख रहे थे, सब कुछ अच्छा खासा चल रहा था, जो कभी भी वर्ल्ड की हिस्ट्री में नहीं हुआ वो हो रहा था। क्या हो रहा था? सऊदी अरबिया और इजराइल के बीच समझौता हो गया था। सऊदी अरबिया जो कि पूरे उम्मा का जो है सबसे बड़ा लीडर समझा जाता है, जहां मक्का और मदीना है, वो एक यहूदी देश के साथ समझौता कर रहा है, क्योंकि उसको अपना डेवलपमेंट करना है, क्योंकि पेट्रोल तो 20 साल बाद खत्म हो जाएगा। तब क्या करेगा सऊदी अरबिया और कतर? दैट्स व्हाई दे वांट टू डेवलप देयर इकोनॉमी, अल्टरनेटिव टू पेट्रोल इकोनॉमी। अब इन बेवकूफों को कौन समझाए? आपको किसे, अगर हमसे कोई कहे, अगर हमसे आपसे कोई कहे कि आप जो है फिदाइन बन करके जाइए और किसी मस्जिद में चले जाइए और वहां बम फोड़ दीजिए और 50 मुसलमानों को मार दीजिए, हम जाएंगे? एक भी हिंदू नहीं जाएगा। क्यों? हम समझदार लोग हैं भाई, किसी के बहकावे में थोड़ी नहीं बम बांध करके मस्जिद में चले जाएंगे और वहां फोड़ देंगे। कभी आपने सुना हिंदुस्तान के इतिहास में कि कोई भी हिंदू टेररिस्ट मस्जिद में गया और बम फाड़ करके वहां 50 लोगों को मार दिया? नॉट अ सिंगल केस। ओके, विद इन 5 मिनट्स टाइम आई एम कंक्लूडिंग। हाँ, विद इन 5 मिनट्स टाइम। हाँ, तो ये 1200 लोग चले गए, स्वयं मर गए और मार दिया, और उसका परिणाम क्या हो रहा है? आज के डेट में 12,000 इजरायली मारे जा चुके हैं और 12 लाख लोग डिस्प्लेस हो गए। माय गॉड, worst violation of human right and misery and destruction and sufferings. Who are responsible for that? Your mind. कहते हैं दुनिया में सबसे ताकतवर कोई चीज है तो वो है दैट इज दी, और वो क्या है? दुनिया में सबसे ताकतवर चीज क्या है? एटम बॉम्ब ताकतवर चीज नहीं है। दुनिया में सबसे ताकतवर चीज है आइडिया। इट इज द आइडिया विच इज मोस्ट पावरफुल थिंग इन द वर्ल्ड। क्योंकि एटम बॉम्ब कहां गिरेगा ये भी कोई आइडिया डिसाइड करेगा कि एटम बम कब गिरेगा और कहां गिरेगा। इसके पीछे कोई आइडिया होगा, आइडिया से ही आइडियोलॉजी निकलती है। तो आइडिया एंड आइडियोलॉजी इज परहैप्स वन ऑफ द मोस्ट पावरफुल थिंग इन द वर्ल्ड। That's why we have to be very careful about the idea and our ideology. Friend, आप जानते हैं कि आपने मुझे टॉपिक दिया है मीडिया ट्रायल्स। शायद आपके दिमाग में होगा कि न्यूज़पेपर्स और चैनल्स, लेकिन मैं उसमें आज की डेट में न्यूज़पेपर से भी ज्यादा पावरफुल, सभी चैनल से भी ज्यादा पावरफुल वो है सोशल मीडिया। फेसबुक, इंस्टा, व्हाट्सएप, and Twitter, X. And that is all political parties. They have created their own IT cells. Every political party has their own IT cells. A friend, since time is running out, now I would like to point out some instances before your consideration. I have heard about the Nithari case. Perhaps you all live in Delhi. Nithari is very close to you. You may be well aware about that. How many children have been killed, sexually abused, assaulted, their bodies were recovered. Bombay terror attack case. Impact of media trial, and very famous Nirbhaya case in Delhi. I can go on and go on, and I can give you at least the 20 or 30 such cases. Whenever any such sensational case come, a friend, do you know that hundreds of the rape cases takes place every day in India? But how many cases gets first heading in the newspaper or in the news channel? I will be lucky if my rape incident is published in the newspaper and I will get attention. And if the channels telecast my case, then I will be able to draw some public media attention. But 98% of the crimes which are not reported in the newspaper, they are not able to get public perception and attention, proper attention of the judges. So even judges, they give importance to only those cases which gets everyday media bite. This is very unfortunate. This is very, very unfortunate. If sexual assault takes place at Varanasi or in a village or at Connaught Place, rape is rape. But there will be media trial, there may be day-to-day hearing. If rape takes place in Delhi, but if rape takes place in some small city, in some small town or in some village, and if they are not able to get the media attention, then it is extremely difficult to get attention of the judiciary. Fast trial. Friend, somebody has told me that जो काम बड़े से बड़ा हथियार नहीं कर सकता, वो काम एक कलम कर सकती है, पेन कर सकती है. So the pen is very powerful tool. But friend, let us have the postmortem of this pen. मैं एक दो बात कहकर के अपनी बात खत्म करूंगा। 90% जर्नलिस्ट और मीडिया पर्सन्स जो मीडिया हाउसेस में काम करते हैं, वो इंडिविजुअली वो कुछ भी सोचें, लेकिन लिखते वो वही हैं जो मीडिया हाउसेस की पॉलिसी है। अगर आप एक मीडिया हाउस छोड़ करके दूसरे मीडिया हाउस को ज्वाइन करते हैं, तो यू हैव टू अडॉप्ट द पॉलिसी ऑफ दैट मीडिया हाउस। एंड और फ्रेंड, हम लोग जनरली ये समझते हैं कि न्यूज़पेपर में अगर कोई चीज छप गया तो ये भगवान है। 15-20 साल एकेडमिक्स में रहने के बाद मैं ये समझ पाया कि न्यूज़पेपर, आजकल तो मैं न्यूज़पेपर भी मैंने पढ़ना बंद कर दिया है, क्योंकि मुझे पता चल गया है कि न्यूज़पेपर पढ़ने से कोई फायदा नहीं, क्योंकि उसमें तो एक पर्टिकुलर व्यू पॉइंट, हर न्यूज़पेपर का पर्टिकुलर व्यू पॉइंट है, हम ट्रूथ तक पहुंच ही नहीं पाएंगे। और सारी की सारी मीडिया जो है वो, आप इंटरनेशनल मीडिया उठा के देख लीजिए, हमारी जो वेस्ट की मीडिया है वो इंडिया को लेकर के कितना बायस्ड है, थर्ड वर्ल्ड कंट्रीज को लेकर कितना बायस्ड है। मैं केवल यही बात कहना चाहूंगा कि फ्रेंड, ऑफ कोर्स you are all young lawyers and you may be concerned about the impact of media on judges, but friend, do we have any remedy? Even all the judges read the same newspaper, they saw all the same news channels, they go the same Facebook post, WhatsApp, Instagram and Telegram और Twitter। जो हम पढ़ते सुनते हैं वही चीज जजेस पढ़ते हैं। जजेस के लिए अलग से न्यूज़पेपर नहीं छपता है, उनके लिए अलग से चैनल टेलीकास्ट नहीं होता है। जजेस आर द सेम ह्यूमन बीइंग एज वी आर। आप अभी लॉ करके आप प्रैक्टिस कर रहे होंगे, अभी कल को आप जो है जुडिशियल सर्विसेज में बैठेंगे, आप जज बन जाएंगे। तो क्या जब आप जज बन जाएंगे तो वेदर यू विल बी डिफरेंट पर्सन? नो, यू विल बी द सेम श्रेया। If you are casteist, you will be the same casteist even after becoming the judge. If you are communal, you will be the same communal judge even after becoming the judge. So friend, what is the way out? The way out is sensitization, education, awareness, empowerment, training. If you want that our judges should be away from media trial or ill impact of the media, you have to have a very good judicial training institutes where the judges must be sensitized, where the judges must be educated. Look, कि जो आप न्यूज़पेपर पढ़ते हो, ये न्यूज़पेपर, ये सारे के सारे जो न्यूज़पेपर हैं एक्सेप्ट 1 or 2, they belongs to that industrialist house, they belongs to this industrialist house. they belongs to this political party, they belongs to that political party. और इसलिए न्यूज़पेपर पढ़ करके और एक पर्टिकुलर चैनल देख करके कभी कभी तो कोई एक इंसिडेंट होता है और उस दिन मैं कई चैनल्स की न्यूज देखता हूं और हर चैनल को देखने के बाद मुझे बिल्कुल पता चल जाता है कि ये चैनल यही बोलेगा और ये चैनल यही बोलेगा, ये चैनल ये छुपाएगा, ये चैनल ये छुपा लेगा। और वही जजेस देखते हैं। जजेस के पास तो इतना टाइम नहीं है ना भाई कि वो सारे चैनल देखें। टीचर के पास टाइम हो सकता है, मेरे जैसे खाली आदमी के पास में जिसको पढ़ने पढ़ाने रिसर्च के अलावा और कोई काम नहीं है, लेक्चर सुनने और लेक्चर देने के अलावा मेरे पास क्या काम है? और कोई काम नहीं। लेकिन जजेस के पास कहाँ टाइम है? उनको तो सांस लेने का टाइम नहीं है, इतना केस लोड है। वो तो एक चैनल सुन ले, एक न्यूज़पेपर पढ़ने बहुत है। तो समय समय पर उनकी ट्रेनिंग होनी चाहिए, उनको बताया जाना चाहिए, पूरा मीडिया का इकोनॉमिक्स बताया जाना चाहिए, मीडिया का पॉलिटिकल एंगल बताया जाना चाहिए। अमेरिकन मीडिया, वेस्टर्न मीडिया, थर्ड वर्ल्ड मीडिया, इंडिपेंडेंट मीडिया, अल जजीरा, उनको बताया जाना चाहिए कि यू शुड नॉट गेट इन्फ्लुएंस्ड with the news, because news and you must develop the capacity to differentiate between the news and views. Most of the newspapers, they are not giving the news, they are giving the views. Politically loaded news. So friend, I have taken too much time. I am very sorry for that. And I may be excused if I have spoken out of way or here and there. But at the age of, I'm just approaching at the age of 60. So I have only 5 years time to get my retirement. So nowadays I'm becoming a little bit blunt. Whenever I'm speaking, I'm sorry, I'm not politically correct. So that's why, and I love my job. Why? Because as an advocate, you do not have freedom in the court. As a judge, you do not have the freedom. But as a professor, I have 100% freedom. Even I can criticize the Honorable Prime Minister of India. So I love my job. And this is the job of a teacher, to speak the truth and to explore the truth and to share the truth. If the teacher will not speak the truth, then the future of this country will not be in the safe hand. Because teachers are nation builders. I'm very thankful to Delhi Judicial Reform Committee and their office bearers. You have tolerated me so much. I'm thankful to you and I wish you all the best. And tomorrow is the Constitution Day or National Law Day. Perhaps most of us belongs to that. So I wish a very happy Constitutional Day. Thank you so much. God bless you.
Thank you so much, sir. Your ideas led us to delve deep into the world of knowledge and understanding as we listen.
Thank you so much, sir.
Accepting your invitation to share this expertise and vision, and it is our honor to have Shailendra Kumar Gupta sir to illuminate our minds and inspire our hearts. Now we have with us Ms. Vishaka Kaushik, the President of Delhi Judicial Reforms Council. Vishaka Kaushik is a fourth-year student of law specializing in intellectual property rights. She has been working with the National Judicial Reforms Council since August 2022 and has left no stones unturned to foster the growth of DJRC in the capacity of the President. Now, I'd like to request Vishaka to take over and give the vote of thanks. Yes,
Yes.
you're audible, Shaka.
I'm sorry, Vishakha. Are you going to put my presentation on YouTube? No, 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 no. I was thinking that if I was aware that my lecture will be put on the YouTube, I would have been more politically correct. I would, I, I would have restrained myself. No, 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 no. Uh, because as I have said that, uh, I think that we need more and more independent voices in this country, and we should talk to each other. We should listen each other very carefully. I should not boast that my views are 100% correct, or I'm only knowledgeable person, or I only know the final law. No, I must be ready to learn from even a young persons. I may be wrong. I may be wrong. So at any point, Vishakha, believe me that I listen at least 3 lectures per day from the YouTube. Nowadays, from last 1 years, I have heard hundreds of the lectures on geopolitics and geoeconomics. And I think that what I have learned from last 1 years, perhaps I had not learned it 20 years time. So every day, every passing months and year, I feel that today I have become more wise. So this is a continuous process, Vishakha. This is a continuous process. So whatever I have spoken today, if I will get a chance after 1 year, perhaps I will speak something else. So thank you very much for giving me this opportunity. Yes, I extend my blessings to all the participants and office bearers.
Thank you so much, sir.
Thank you so much, sir.
Thank you, sir.
Thank you so much, sir. We are incredibly privileged to benefit from the wisdom shared by you. I take this opportunity to express our heartfelt thanks to the esteemed speaker for taking out the valuable time for their busy schedule and the participants for their participation. Your presence has graced the event and added feathers to the cap of Delhi Judicial Reforms Council. Thank you so much.
Yeah, sure. Yeah, it will get disconnected. Yeah. Thank you, everyone.